We've all heard the word negligence thrown around, right? Usually it's after something's gone wrong. But what does it actually mean in the eyes of the law? It's this fundamental legal idea, but it's not just for lawyers. It's really about the basic responsibilities we have to one another every single day. And that brings us to the big question, doesn't it? Accidents happen. That's life. But when does a simple mistake cross the line and become something legally significant? Well, it turns out the law has a very specific step-by-step way of figuring that out, and that's exactly what we're going to unpack. At its very core, the legal definition of negligence really hinges on two keywords: reasonable care. See, it's not about being perfect. It's not about preventing every single thing that could possibly go wrong. It's about being as careful as a normal, sensible person would be in that exact same situation. That's the yardstick we're all measured against. So to prove negligence in court, the person bringing the case, they're called the plaintiff, can't just point a finger and say, your fault. They have a very specific job to do. They have to prove three distinct, non-negotiable things. Not one, not two, all three. Think of it like a combination lock. You need every single number in the right order for it to open. And here they are. I like to think of them as a three-legged stool. You've got to have all three legs for the stool to stand up: a duty of care, a breach of that duty, and harm that resulted from it. If even one of those legs is missing, the entire claim of negligence just falls apart. So let's look at each leg, one by one. All right, let's start with that first leg of the stool, the duty of care. Before you can even begin to talk about whether someone was careless, you first have to show that they had a responsibility to be careful in the first place. So here's the official legal language. It says the tortfeasor, which, by the way, is just a fancy term for the person accused of doing the wrong thing, owed a duty of care. In plain English, you have to prove that the person who's being accused had a legal obligation to watch out for the safety of the person who got hurt. So what does that look like in the real world? It's actually pretty simple. Drivers have a duty of care to everyone else on the road. Doctors, obviously, have a duty of care to their patients. A shop owner has a duty of care to the customers who come into their store. It's this established legal relationship that basically says, hey, you need to be mindful of this person's safety. Okay, so let's say a duty of care exists. Pillar 1 is standing, but that's not enough, not by a long shot. Let's move to the second pillar and see how this builds, proving there was a breach of that duty. The next step is to show a breach of that duty. So once you've established that, yes, a responsibility was there, you then have to prove that the person failed to live up to it. They had a job to do, be careful, and they just didn't do it. This is the careless part of negligence we all think about. The driver who's texting instead of watching the road, the doctor who didn't wash their hands before a procedure, the store owner who knew there was a big spill on the floor and just ignored it. In each case, they fell below that standard of reasonable care. That failure, that's the breach. Okay, so we've got a duty and we've got a breach of that duty. We are almost there. But there is one final, absolutely crucial piece to this whole puzzle. You have to prove that the breach actually caused some kind of harm. Now pay really close attention to these words here. As a result of. This is all about causation. It's not enough to just say someone was careless. You have to prove that their carelessness was the direct cause of a bad outcome. This means you have to connect the dots with a straight line. The texting driver caused an accident that led to medical bills. The unwashed hands led to a serious infection. The slip on the wet floor caused a broken leg. If the careless act didn't actually lead to any real, measurable harm, then legally there's no negligence. So let's put this all together. I think the most important thing to take away from all this is that these three pillars, duty, breach, and harm, they're not a menu you can pick and choose from. They form an unbreakable chain. Let's go back to that three-legged stool one last time. Imagine a doctor owes you a duty of care, and they breach it by giving you the wrong advice. But you realize the mistake, you don't take the medicine, and you suffer zero ill effects. Well, what's missing? The third leg, harm, is gone. The stool topples over. The negligence claim fails. You have to prove all three, absolutely. And this leaves us with a really fascinating final question to chew on. This framework of three pillars is universal, but that core concept, reasonable care, is incredibly flexible. I mean, think about it. Is the reasonable care you expect from a professional airline pilot the same as the reasonable care you expect from a teenager babysitting for the very first time? The law says no, it's not. And thinking about how that standard changes from situation to situation, well, that's the key to really understanding how negligence works out in the real world.